Yeah, Gordon, reliably with the problem question. We can start there if you like. Problem question 23. Anyone got any ideas? Yeah, good, Murray. Very good. But you'll find actually that most of the problem questions are slight variations on the major cases that are allocated. Gordon, you want to deal with the nature of implied natural justice, and more specifically, something? Anthony, are you talking? Because if you are, you're not coming through. Okay, if you're having problems with the mic, why don't you just type it out? Let me say a couple of things about natural justice, just recapping on last week and the issues that you guys have raised already. So just by way of recap, going back to early principles of administrative law, you'll all remember that one of the first things we learned, and it's common throughout most legal subjects, you'll find it recurring for the most part, is that our legal system has a history, an 800-year history of evolution through common law, so judge-made law, and the creature, as we sometimes describe it, of statute law is a relatively recent phenomenon. The amount of statutory law that has started to impact on the way the law works has grown exponentially in the last sort of half century or so, but even more significantly in the last 20, 30 years. That's important for this reason. The principle of natural justice is of common law origin, and that's one of the first things that you'll see in the notes. And what the common law has to say about natural justice, and you'll see this picked up in Chiara and West, which I hope you've all had an opportunity to read, because it, together with, for example, Attorney General and Quinn, are very significant cases, and certainly ones which you'll all want to be familiar with for the purposes of the exam. Say that unless a statute, let's take for example the in the case of problem question 23, the Business Regulations and Control Act, ousts the principle of natural justice, it will be implied by the common law. So what that means in a practical sense is this: if an administrative decision maker is empowered to make a decision or have some sort of effect on personal rights and liberties, unless the act under which they are making a particular decision ousts natural justice, either entirely or in part, then the common law will intervene to imply it. So if I'm an administrative decision maker and I'm making a decision of any kind and it's going to affect one of you, then the starting point will be that before I make the decision, I have to afford natural justice. And you'll recall from last week I discussed how natural justice and procedural fairness are used somewhat interchangeably in modern administrative law, but that at its core what that means is, in the nature of the fair hearing rule, an opportunity to be heard. So if I'm going to make a decision which affects you, let's say I'm going to issue an administrative fine of some sort, and we're creeping into criminal law, I know, but it arises as a result of problem question 23, so let's just deal with it. If I'm going to impose some sort of administrative penalty and I haven't given you an opportunity to explain why it should not apply, then I will have failed to accord natural justice or procedural fairness, and my decision will be liable to be struck down. How can anybody give me some insight into how that might work in a practical sense? How would you go about ensuring natural justice is applied to the decision in the case of, for example, problem question 23, assuming that I'm the Chief Executive of the Australian Business Regulatory Agency and I've come around and taken all your papers and issued you with a fine? Anyone? Good. So Annette says apply for judicial review. Anyone else? Kylie says his property rights were affected. That's certainly true. Whether it's his property rights or some other right is perhaps not particularly important, because his rights have been affected. What would he do about it? The exam will most likely ask you in a problem question type way to be able to articulate what should be done about this sort of a circumstance. What, in a practical sense, are your tools that are available, assuming that you guys are solicitors in a couple of years and somebody came to you in this sort of situation? What are you going to do? Good. And so the first thing to do is to say, as Annette says, is what we're going to do is identify the particular piece of legislation, presumably, under which the administrative decision maker has acted or purported to act, and what are we looking for. So in the context of this week's course materials or course content, okay, so go back a step. So we've got Kylie saying, have a look to see whether or not there's an intent that natural justice wouldn't apply. That's certainly something we're going to do in the course of resolving the issue that's been identified in problem question 23. Jimmy says check if natural justice is expressly excluded, which is sort of the same thing, and again it's something we're going to get to. Peter says which judicial scheme applies. Anthony says whether or not the administrative people have acted lawfully. raise, jumping ahead to determine whether or not judicial review or merits review, which is certainly correct, but a little bit further down the track. Murray says identify the power granted, and I think that's probably pretty close to the starting point. So the first thing we're going to want to do is to have a look and to identify the legal provision, and you can probably assume in contemporary administrative law context that it's going to be a piece of legislation, whether it be an act or a subordinate instrument like a regulation. And we're going to see whether or not the decision maker had the power to make the decision in the first place. So this is now sort of going back to cover the material that we've been dealing with up until now. So the first thing is to identify the power, because the first thing we're going to want to know is whether or not they had the power at all. If they don't have the power, if they've made a decision or purported to make a decision and to affect personal rights which they were not entitled to do, then we're not even going to have to worry about natural justice, because we're going to have a basis to argue that the purported decision was what we call void ab initio, that is, void from the very beginning, on the basis that it was ultra vires, being exercised beyond the powers which the person actually was able to exercise, that is, the administrative decision maker was actually able to exercise. And that would be, in effect, the end of the inquiry. What we would be doing is we would be filing an application in the Supreme Court of the states, or in the case of a Commonwealth decision maker, probably in the federal court. And the High Court, as you all know by this stage, also has an original jurisdiction to supervise officers of the Commonwealth. And we would be asking for a, in effect, what used to be called a writ, but is now, in contemporary law, superseded by the notion of declarations, that the administrative decision maker was acting beyond the power and that the purported decision was of no effect. So we would be saying, in the case of problem question 23, that the ABRA, the Australian Business Regulatory Agency, was acting ultra vires when they purported to attend, well, when they did attend and seize papers and exercise or purport to impose a fine. And we would then, obviously, as a matter of practicality, be asking for some further relief in the nature of an order, which might be a type of positive injunction requiring them to return those items to us, that is, the goods, documents and papers, and what we call a negative injunction, which restrained the ABRA from imposing a fine or taking any steps to enforce the purported fine. So that's step one. That's where the administrative decision maker is acting beyond their power or without a power at all. And we've dealt with that in past weeks. Let's move to the other scenario where there is a power, for instance, for the ABRA to attend the premises and seize goods and documents and impose fines, but we'd be making an inquiry into how that power was exercised. So that is sort of where we're at in this week's material, and we would be looking for at the Act, the Australian Business Regulations Control Act, to say, is there any provision within that Act which ousts the principle of natural justice? So we'd be, an example of where you sort of find it in a limited sense is in the acts which affect the exercise of power by regulatory agencies, and in particular sort of the corruption agencies. So natural justice has a reduced impact under the Independent Commission Against Corruption Act in New South Wales, in that the ICAC is not required to tell a what the expression used is affected person, or which is perhaps somewhat a euphemism for a target of the investigation, why they're investigating, precisely what they are investigating, what evidence they've got. As to that second point about precisely what they're investigating, they're required to give such information as is reasonably required to allow an affected person to make a response or to fairly participate in the investigation, but they're not required to lay out in chapter and verse everything that they have or are concerned with, because to some extent to run an investigation, or to a great extent, running an investigation requires a degree of subterfuge, so that if you tell, you can all understand, I imagine, that if you tell a person exactly what it is that you're investigating, and in fact in the case of corruption they have been involved in corruption, then you're basically setting up a situation where they might be able to run a type of interference or prevent the investigation from being undertaken as efficiently and effectively as possible. So there's a degree in those, there's an extent of limited natural justice that's required by the ICAC Act, and I don't have the provision at hand, but you'll all be able to find it relatively easily. Where that doesn't exist, what the law says, and this is from Kiowa and West, as Gordon points out, and which you'll find in the notes, in the absence of an ouster provision, natural justice will apply. So what is the effect of that in the context of problem question 23? If we've gone to the Act and we've had a look to see whether or not there's any ouster, and it's the case that there is no ouster, what effect is that going to have on the facts in problem question 23? Over to you guys. Okay, so Jessica says common law rules apply. So the starting point is, we will say, well, we've gone to the Act, natural justice is not ousted in any express way, and therefore following what is said or concluded by the majority in Kiowa and West, and there are other authorities of course for this particular proposition, but the leading case tends to be the High Court in Kiowa and West, that natural justice will be implied. So if what we've got here is the ABRA turning up, seizing our documents and applying fines without ever asking us to explain, for example, why we haven't registered our business. And so what effect will that have on the action which is being taken by the ABRA? Anyone want to proffer a guess? Gordon's on the right track. He says fair hearing question mark. Anthony says it'll be negative. That's right. How? What are we going to say? What are we going to tell our client? Okay, look, that's a pretty fair contribution, I would say. I think each of Murray, Annette and Ray's positions are probably summarise what we're going to tell the client. We're going to say, look, this is how I would respond to it. I would be saying to Aaron Lamb, Mr. Lamb, the position is this. Your rights, interests or legitimate expectations, to borrow from the expression used in Kiowa and West and Jarrett and the Commissioner of Police, have been affected. They have been affected in the sense, as Ray has pointed out, the category referred to in Cooper and the Board of Works, that no man shall be deprived, or woman for that matter, shall be deprived of his or her property without an opportunity of being heard. That is the starting point. I have had a look at the Australian Business Regulatory, the Business Regulations and Control Act, and there is nothing in that Act which says that the Australian Business Regulatory Agency is entitled to act other than in accordance with the common law requirements for natural justice to be applied. And I'll talk in a minute about the difference between, for example, natural justice and a fair hearing, just to pick up on an expression used by Murray there. As a result of not having been given an opportunity to be heard or to respond to the, in effect, allegation or the decision that the ABRA has reached before it came out to seize your property and to impose a fine, natural justice has not been applied. Therefore, in my opinion, the ABRA has acted unlawfully, and you are able to challenge their actions in the in this case it'll be the federal court, won't it? Probably, because we're not going to go to the High Court on a point such as this where there's a procedure available to go to the federal court. And we will, and this is something that hopefully you've all addressed in your assignments, and I'll probably talk a little bit more about the assignments in later sessions. There's just a couple of people who haven't submitted yet, so I won't deal with that this week, but I'll deal with that next week. But what we'll be saying is the ABRA haven't given you an opportunity to be heard before they've reached this conclusion, which gave rise to them seizing your property and purporting to impose a fine. So what we're going to do is we're going to go off to the federal court, and we're going to ask them for relief, and we're going to ask them to declare, firstly, that natural justice is not ousted by the Business Regulations and Control Act. We're going to ask for a declaration that the Australian Business Regulatory Agency failed to accord natural justice. We are going to ask the court to restrain the ABRA from taking further actions to seize goods, documents and papers, we're going to ask the federal court for a mandatory injunction requiring them to return the goods, documents and papers. We're going to ask for a injunction or a declaration that the fine they purported to impose is void or of no effect. And we're going to ask, I think this is the final part probably, we're going to ask for an order in the nature of certiorari, which we will come to, which uplifts the record from the ABRA and places in the hands of the federal court, where we will have struck from that record any reference to a failure to comply with the Business Regulations and Control Act, and specifically those parts which prohibit operating without a registration. So you can see there that there's sort of a number of different steps, and you have to break it down. First thing we have to do is we have to say, well, natural justice does apply to this particular law. Then we say the agency created by this particular law, or the agency that is otherwise required to enforce this particular law, hasn't acted in accordance with the dictates of natural justice, and then we're going to try and get consequential relief working down from that. Is everybody following so far?
Yes, I am.
Okay, good. Seems like everybody. Peter's, you're saying I think so. Anybody who isn't following or has questions that flow from the things I'm saying should just jump in. Whilst you guys are formulating your thoughts, let me just read up a bit to see what Peter, Gordon and Jolan were saying. Okay, that's a good question, Peter, which I suppose is why you say you think so. I'll come to your question in a second. Let me just quickly read Gordon's. Okay, Gordon's got a good question there about what if your property is seized in order to determine whether you've committed an offence? That is going to probably start to move down the scale of implied natural justice. So at one end, you've got decisions of a agency which are of a commercial nature or non-investigatory in nature, and you'll recall from previous sessions we've dealt with the distinction between sort of investigatory administrative law at one end and decision-making administrative law at the other. As you get closer towards the investigatory end, what you'll find is a sliding scale away from an implied natural justice, so the ICAC, for example, that I gave you. And in Gordon, what Gordon has said there talks about what if for example, the ICAC are investigating, or in this case the ABRA are investigating, and they have got a search warrant usually these agencies will need a search warrant. You can't just turn up and enter your premises. There are some exceptions. But if they've got some lawful power to attend the premises and to seize documents or other items as part of an investigatory process, then you wouldn't expect natural justice to be implied, because you can imagine there's no real public interest behind requiring somebody who's investigating, and it tends to be more in the criminal offence arena. You can imagine that they wouldn't, the law as a matter of public policy, wouldn't expect that sort of investigatory body or regulator to telegraph the fact that they're going to come over and try and collect evidence and to get your views on it. That just, you can imagine, wouldn't make any sense. It'd be like the police broadcasting that they're going to go and arrest somebody and give them an opportunity to flee or to get rid of evidence. Just, it's not consistent with our legal system. But at the other end of the spectrum, and this is not one where there's any suggestion, that is problem question 23, there's no suggestion it falls into that category. This doesn't appear to be a case of they're investigating, so they need goods, documents and papers. This is a case of they've decided that there's been a failure to comply. they've come over to seize goods and papers and to sort of use them as a type of collateral until a fine is paid. So there's no real investigative purpose. It's sort of punitive in a way, in a very significant way. Hopefully that answers your question, Gordon. Now let me come back to Peter's comment, which is how would you determine whether to pursue a remedy, I think you mean there, under the Judiciary Act or the ADJR when both allow for natural justice? Now this is a really important question, everybody, because it deals with the contrast between administrative decision making to which the ADJR Act will usually apply and the sort of excessive or enthusiastic enforcement by regulators. Now, when the ADJR Act will tend to apply in the context of an administrative decision maker who is making a administrative type decision in a tribunal sense. So they won't necessarily be described as a formal tribunal, but they will be basically exercising a sort of function as a tribunal. And in exercising that sort of function as a tribunal or a decision maker, they'll be required to accord natural justice or procedural fairness, which when you strip out that lingo is basically a requirement to give a fair hearing, because that's what they're doing. They're hearing evidence and they're making an administrative decision. On the other hand, at the other end of the spectrum, and this is where judicial review would apply, and where you've got judicial review, you necessarily need to draw in the Judiciary Act in the Commonwealth arena. That is where you're trying to restrain not so much an administrative decision maker who's adjudicating like a tribunal, but a decision maker who is, sorry, a executive decision maker or an executive body which is overreaching. And in this particular case, what we have is this is not somebody who, the ABRA in this set of facts is not simply hearing evidence and deciding yes or no, Aaron has failed to comply with the Business Regulations and Control Act. This is an agency that has decided that he has done that and then is taking action to enforce its conclusion, and that falls into the judicial review arena. Now, I'm not sure if that's clarified it for anybody. Does that help, or are we still a bit in the dark? Deafening silence. Kylie didn't follow. Okay, good.
I didn't really follow either.
Okay. If nobody's followed, let me see if I can break it down a bit. All right, let me use the ADJR Act, Murray, is a different type of remedy to judicial review. It does apply. It's a statutory mechanism for judicial review, but it's used in a different way. That is, it's designed. The ADJR Act is designed to review administrative decisions in an appeal type setting. The judicial review, in the sense of the sort of remedies which arise by filing a summons in the federal court and seeking to restrain executive decision makers from exceeding their power, is a different sort of function. Let's break it down. Let me see if I can explain it for you this way. You've got, in this particular problem question, you've got the Business Regulations and Control Act. And I'm going to build on with a hypothetical scenario, try and demonstrate how these different mechanisms might work. let's assume that there are two functions given to the Australian, let's go back a step. There's the Business Regulations and Control Act, and let's assume for a minute that it creates the Australian Business Regulatory Agency. In fact, everybody get out a pen and paper just so you can follow where I'm going with this, so that it sinks in. I'll be doing the same. Okay, Jolin's ready. Just to answer your question, Peter, there where you asked, would Judiciary Act apply where you're seeking a declaration or injunction? The answer is yes. That's exactly where it would apply. I'm going to try and demonstrate that here. So I want everybody to start at the top of the page. You've got the Australian Business Regulation, you've got the Business Regulation and Control Act. I want you to assume for a minute that Section 1 establishes the Australian Business Regulatory Agency. I want you to assume that Section 2, and I'm writing these down as we go, so I hope you all are as well, and this is just by way of example because this is of course a fictional act. Section 2 says that the purposes of the Australian Business Regulatory Agency are A, to receive and process applications for carrying on a business. Okay? I want you to assume that Section 2, subsection B says that the other purpose of the Australian Business Regulatory Agency is to enforce compliance with the Act. Okay? And then you can assume, and you don't need to write this down, that the Act goes on to basically provide more detail about how those sorts of functions are to be performed by the Australian Business Regulatory Agency. Now, Section 2, subsection A says that it is to receive and process applications for carrying on a business. Let's assume that Section 3, now you can write this down, Section 3 sets out the test for when a person should be successfully granted a license to carry on a business, right? So Section 2A says this agency has to receive and process the applications. Section 3 says when it does that, here is the test for how to consider whether or not a person should actually be given a license. And let's say that test number 3, Section 3, subsection Roman numeral little I says, well, the first requirement will be that you've got a Bachelor of Business. Let's make that the first requirement. And let's say the other requirement, so this will be Section 3, little Roman numeral 2, says that the other requirement to be granted a business license is that you're a person of good character with no convictions. Now, let's assume that Aaron Lamb wants to apply for a business license. So he puts his material together and he sends it off to the Australian Business Regulatory Agency, and he says, here's my certificate that says I've got a Bachelor of Business from CQU, and here is my criminal record from the Queensland Police that says I've got no convictions. Right? Under Section 2, subsection A, the role of the ABRA is to receive and process that application. And we can assume that that means to receive and process it on behalf of the agency and to do so in accordance with the test set out in the Act. Now, let's say Brett Urell works at the ABRA, and I receive this application from Aaron Lamb, and I say to myself, okay, he's got a Bachelor of Business and he's a person of good character, but I heard at the pub the other week that he was about to get charged for cattle rustling. Okay. Now, I then take that into account as the officer at the ABRA who is processing this application, and I say, well, he might be a person of good character now, but as I understand it, he's about to get charged and he may be ultimately convicted, and so he won't be a person of good character in the future, and so I'm going to decide to reject this application, right? So I arrive at the conclusion that it should be rejected. Now, I have just performed basically the function of a tribunal, okay? I have received an application and I've processed it, and I have committed a number of sins. Who can tell me that is as an administrative decision maker? What are the examples of some sins that I've just committed as the decision maker?
Taking into account irrelevant considerations.
Okay, good. Who's that? That was Ray, was it?
No, Jolyn.
Jolyn. Okay, good. One of the things I've just committed is I've taken a irrelevant consideration into account, because I'm required to consider whether or not he's a person of good character, and let's assume for a minute that the Act defines a person of good character as someone with no conviction. He's got no convictions. It doesn't matter whether or not at some future time he might get a conviction. That's not part of my function, so I've taken into account an irrelevant consideration. What else have I done? And I'm thinking specifically about this week's materials.
You haven't given him an opportunity to explain that conviction, possibly?
So I've denied him a fair hearing, or I've denied him procedural fairness or natural justice, however you want to describe it, by not following the fair hearing rule. What I should have done, assuming that it's not a completely irrelevant consideration in the first place, is I should have written to Aaron Lamb and I should have said, Aaron, thank you for, and this is just one way to go about it, but it's an example of how you would expect most agencies to do it. Aaron, thank you for your application. We've received your certificate proving that you've got a Bachelor of Business, and we've got your criminal record that shows that you've got no convictions. However, we have heard that you're about to get a conviction. I should put that to Aaron, because remember, I've heard this at the pub. It's hardly a reliable source of information, even if it were relevant. And Aaron might come back to me and say, dear Brett, thanks very much for your letter. I don't know why you've heard that, but I can confirm that I haven't been charged, I don't expect to get charged, and that I remain a person of good character. Yeah? So you can see that's how the fair hearing rules work. Now, I haven't done that, even though it's what I should have done. As an administrative decision maker, and let's go back to our pen and paper for a second, let's assume that Section 50 of this Act says that this is legislation to which the ADJR Act applies. What are the remedies that are available to me, what are the remedies that are available to Aaron Lamb at this point? Hint, all you need to do is go to page 13 of this week's lecture notes, and you might find it towards the bottom of that page.
The ADJR Act provides an order of review can be sought.
Yeah, so the Administrative Decisions Judicial Review Act in Section 51A says that as an administrative decision maker, I am required to afford or to comply with the rules of natural justice. So what have we got there? What does that mean in effect? If Section 50 of the Business Regulations and Control Act says that this is a piece of legislation to which the ADJR Act applies, and we jump to the ADJR Act and we find there that as an administrative decision maker I was required to follow the dictates of natural justice, and we have already established that I haven't, what's the next step? What are we going to do? What can we do as a result of the ADJR Act? Who can we go to? Can we go to the, so we can go to the Administrative Appeals Tribunal for review, can't we? Is everyone with me so far?
I am now.
Okay, so what we're going to do, so let's assume for a minute that you guys are all lawyers. Let's skip ahead a couple of years. You've all successfully completed your undergraduate law degree and you've gone through the College of Law and you've been admitted as solicitors of the respective states and the High Court of Australia, and Aaron Lamb comes in to see you and he says, look, I'm a businessman. I graduated from CQU. I actually remember you from the CQU year of graduation, and I really need some help from you. I'm a businessman. I've applied to this new agency, the ABRA, and this cretin, Brett Urell, processed my application and decided that because he'd heard at the pub that I might get a conviction at some stage in the future, he's knocked back my application. So you guys then, you look at the Business Regulations and Control Act and you go through and you see under Section 2, subsection A, okay, well Brett as the Chief Executive or one of the officers of the ABRA was entitled to receive and process applications. So he is acting within power at this stage. Then you go to the test and you have a look at the test and you say, okay, well the test was he was to decide whether or not he had a Bachelor of Business and a person of good, and Lamb was a person of good character, and Lamb appears to meet that test. So it looks like Brett Urell has taken into account on behalf of the ABRA an irrelevant consideration. And not only that, it looks like he never actually sought Aaron Lamb's input on whether or not this information was even true, and as a result of taking it into account, it has had a direct impact on the decision that has been made, and he has done so without getting Aaron's input, and it's ultimately affected his rights. So it looks like there is a denial of natural justice, and then you're going to go to Section 50 and you're going to say, oh, okay, so I see that this is a piece of legislation to which the ADJR Act applies, so let's get the application form from the Administrative Appeals Tribunal and let's file an application for review of this decision and get somebody who's going to make the decision properly to remake it. Kylie asked, wouldn't the Act need to specifically allow an appeal to the AAT for that? If I wasn't clear about that, then what I mean by Section 50, yeah, I can see why that would arise, Kylie. Whenever you see a reference, for example, to the ADJR Act, assume that what it is intending to do is to say the Administrative Appeals Tribunal is available as a remedy. So you've got Section 50 saying that the AAT is available as a body to reconsider or adjudicate, re-adjudicate this particular piece of, or decisions made under this particular piece of legislation, and that's what we're going to do. So we go off to the Administrative Appeals Tribunal and we ask them to reconsider the decision, and we put forward to the AAT as one of the jurisdictional grounds which get us there that there's been a failure to comply with this particular legislation. No, it doesn't, but what I'm trying to, sorry, Kylie asked, does the ADJR Act need to be specifically referenced in an act like the AAT Act? Sorry, one second. I must have missed a question from Peter because it's being asked, because Jolin's saying, so in answer to Peter's question, you would have to look at the piece of legislation to determine the appropriate act to apply. So, as a matter of common drafting, what you will find in legislation, Commonwealth legislation, which has an administrative aspect to it, is the provisions for review. And this is come and go onto the AAT website, have a look at the legislation that they have power to review or administer, and you'll consistently find sort of towards the 3/4 mark or even towards the end that there is a reference to the Administrative Appeals Tribunal being a power that has, being a body that has the power to review. What I'm trying to get you to make the connection here between is the ADJR Act and the AAT. The function of the ADJR Act, in part, is to give you the tools that you need to get to the AAT. And I'm trying to demonstrate here at the moment the importance or the distinction between, just everybody pick up that piece of paper that you were marking at. You remember that I said Section 2, purposes of the ABRA, firstly under subsection A, to receive and process applications. So that's an administrative feature or function of this agency. Then you've got subsection B, to enforce compliance with the Act. And why I've suggested that why I've set out those two different functions is because in the case of subsection B, we're more into the realms of judicial review, and I'm going to deal with that in a minute. But I want you to understand the distinction between the administrative, truly administrative type function of receiving applications and processing them, and the requirement to comply with the ADJR Act requirements, and the role of judicial review in restraining. So Peter says, and we'll just have a look back at the screen, so the Judiciary Act would be if you want a declaration or injunction, and the ADJR Act would be if you want to remake the decision by the AAT. And that's it. That's basically what I'm trying to demonstrate for you in a practical sense. You remember at the beginning of the term, or semester, trimester, we said you've got judicial review and you've got merits review. In a Commonwealth setting, if you want merits review, and that's usually the cheapest way to go, and how it tends to work is the higher up you get in the chain of merits review, the better quality decision maker you get. That is the more formal training perhaps you can expect from the person who's making the decision. So the President of the Administrative Appeals Tribunal is a federal court judge. And from there down to perhaps the clerk at, the counter clerk at the Department of Social Security, you've got a very broad range of quality in decision makers. And so the purpose of having these review bodies is to go to a better quality decision maker inexpensively. So the first thing we're going to do here is we're going to get Aaron to go and have the decision remade. We're going to go and get a member of the Administrative Appeals Tribunal to have a look at it and say, well, Brett Urell, of course, was not entitled to take into account something he heard at the pub. A, it's irrelevant, and even if it was relevant, Aaron Lamb should have had an opportunity to respond to it before it was taken into account as the very basis for rejecting the application. So you've got those grounds set out in the Administrative Decisions Judicial Review Act for you. Now what I want to do is I want to focus on Section 2B. So the other purpose of this particular regulatory agency is to enforce compliance with the Act. So let's change the facts a little bit for a minute. Let's assume that Aaron Lamb has been told that this Act has come into force and that you cannot carry on a business without a license, and that to get a license you have to apply. And Aaron says to himself, stuff that, not interested in going through all of that bureaucratic nonsense. I don't need a license. I'll carry on a business however I want to carry it on, license or not. So now what I want you to do is to pick up that piece of paper, and I want you to assume that in Section 4 says the powers of the ABRA. And it says that the ABRA is empowered to issue a prohibition order to a person who is carrying on business without a license. So Section 4, powers of the ABRA, subsection A of 4 says one of the powers is to issue a prohibition order to a person who carries on a business without a license. Now, actually, let me change the facts again. Sorry to confuse everybody. Let's go back to Aaron Lamb actually being a good bloke, not a rebel. Let's assume that Aaron has applied for the license. Let's assume that he got somebody sensible under Section 3 to consider the application, and his license was granted. However, for whatever reason, Brett Urell did not update the register of persons who have got a business license, and so one of his colleagues who's responsible for enforcement gets a tip-off that says Aaron Lamb has been carrying on a business without a license. And so he trots off down to the principal place of business for Aaron Lamb's enterprise, and he issues a prohibition order on Aaron Lamb. And the basis of the prohibition order is that you can no longer carry on a business under penalty of criminal sanction if you ignore the prohibition order. And the reason that you can't carry on a business is because you have not applied for and been issued a license. What is our remedy now? Is it different, anybody? I was hoping, Jessica, you were going to say judicial review, because you've got them perhaps a little bit in reverse order. You gave the answer when I asked the question before, judicial review. What you actually meant was merits review. That is, when a person is making an administrative decision which affects you and they don't comply with the requirements to give you, for instance, a fair hearing or natural justice, you apply for merits review to have that decision remade. What we've now got is a executive agency and an officer within an executive agency issuing a prohibition order in circumstances where it should never have been issued. So let's say that under Section 4, everybody go back to the piece of paper. Section 4, powers of the ABRA, A, to issue a prohibition order to a person who is carrying on a business, but only where they are carrying on that business without a license. Now, our power to issue, that is the ABRA's power to issue a prohibition notice, only arises where a person hasn't been issued with a license. And what we know on the facts that we've been discussing is that Aaron Lamb does have a license, and it's only by reason of administrative error in the record keeping of the ABRA that this prohibition notice has been issued to him. So can everybody see how in those circumstances the ABRA has acted beyond its power? That is, it can only issue a prohibition order to a person who hasn't got a license, and Aaron Lamb has a license. Can everybody see that?
Yes.
Everybody? Anybody who can't see it, jump in, because I'll go over it again. Okay, it seems like everyone's got that so far. So we've got the ABRA issuing a prohibition order in circumstances where it had no power to do so. Are we in judicial review or are we in merits review? Everybody?
Judicial.
Judicial review. So what we need to do, so Aaron Lamb comes into us, you guys are all practicing as solicitors, and Aaron Lamb comes into your law practice and he says, I've got this ABRA on my back, I've been issued this prohibition order on the basis that I'm not licensed to carry on a business, but I've already applied for and been given a license to carry on a business. I don't know why this agency is doing this. So what are we going to do? What are you guys going to do? I can't give you the answer because I'm the baddie. And by baddie, I mean I'm the overzealous executive officer or member of an executive agency. What are you guys going to do to keep me under control? We know we're in judicial review, so what are we going to do about it? So judicial review tells us sort of the broad strokes of where we're going to go. What can we do? And I want everybody to think for a minute about Essendon and Asada. Everybody? Okay, so what happened in the Essendon and Asada decision? What was being put?
That Asada acted outside of its powers.
Yep. And what is the remedy where it acts outside of its power?
To declare that they did act outside their power and that it was unlawful.
Yeah. So we're going up to the federal court, and we're going to say where a person who is affected by a decision made by a what? identify an administrative decision maker, and we're going to say we've got what do we need as a threshold question to be able to stand in front of the court and say we want relief. Standing, exactly. So we've got a decision that affects us, that gives us standing, and we want the federal court to help us. And what tools does the federal court have available that we can ask them to utilise to help us? Good. So basically what we start with is we ask for a declaration and we say we need the federal court to declare that the ABRA only has powers to issue a prohibition notice to a person who is carrying on a business but doing so without a license. That's the first thing we want. We want the federal court to declare what the ABRA's powers are. We want the federal court to declare that we were carrying on a business with a license. So, what we're trying to do there is demonstrate that we're not in the category of people to which the ABRA's powers apply. And we want injunction, for example, and there's two types of injunctions. There's mandatory and negative injunctions. So mandatory injunctions being the type that require the ABRA to do something, and negative injunctions being orders which refrain the ABRA from doing something. So in this case, whether it be a negative or a mandatory injunction, we want the prohibition order issued to us to be withdrawn. So that can take a number of different functions. Probably the way I would ordinarily plead it is I would ask the federal court to issue an injunction, a mandatory injunction, requiring the ABRA to withdraw the prohibition order. Does everyone follow that so far?
Yes.
Okay, so we're getting a little bit off the track now because we were really going to be doing natural justice this week, but I just wanted to cover some grounds about the sort of tools that you go to. Now, Kylie, you're asking a good question there about why do we need the Judiciary Act for that? Why can't we use the ADRA-JR Act for the same thing? You can. The Judiciary Act simply says that there are powers of supervision afforded to the courts as a Chapter 3 court with responsibility for supervising the executive. The Administrative Decisions Judicial Review Act is a piece of legislation which steps in over the top of that sort of common law position, because that requirement for courts to supervise the executive is something that stems from the common law Westminster principles of separation of powers. Now, everybody who's had a look at the ADJR Act, and if you haven't already, you need to, should go to Section 5. In fact, everybody just pull up Section 5 if you can, whilst we're all online. And has everyone got it? Let me know when you've got it up. whilst everybody's getting it up, just getting the section 5 up on their screen, just the others can have a read through subsection 1. And in particular, the first line of subsection 1 is what we need to answer Kylie's question, because I might have created some confusion here. So just to settle that, Kylie, the answer to your question is the Judiciary Act expands upon the jurisdiction created for the High Court in accordance with the, pursuant to the Commonwealth of Australia Constitution Act, which was the product of Federation, and the ADJR Act is sort of complementary in a sense, in that everybody will see from subsection 1. Has everybody got that up? Ray, have you got that up? And Jessica? Yep. Annette? Okay. So what you see there is a person who is aggrieved by a decision to which this act applies, right? So that's why I said to you at the going to the pieces of paper that you're hopefully working on, I included section 50 of the Business Regulations and Control Act, which says the ADJR Act applies. Yeah, does everybody see that? Everyone following? So what we've got there is that in order for you to have relief under the ADJR Act, it's got to be a decision to which the Act applies, and that's why I've included section 50 in the hypothetical problem that we're developing here. That is made after the commencement of this Act may apply to the Federal Court, the Federal Circuit Court for an order of review. Okay, so what you've got there is a requirement that the legislation under which the relevant decision is being made is a decision to which the ADJR Act applies. So you've got to have that statutory connection. Now, what is important to remember about the Judiciary Act, and in particular the role of supervision which it grants to the Federal Court and the High Court. Well, the High Court gets it from the Constitution, but what the Judiciary Act says is that the Federal Court and the Supreme Courts of the state have coextensive powers. But what you'll find in the Judiciary Act is this an absence of the requirement that the ADJR Act apply to the decision. So let's assume for a minute that section 50 does not exist in the example that we've been working through. So everybody scrub section 50, which says the ADJR Act applies. You've now no longer got the ADJR Act as a basis for review. So what are you left with? Anybody? Good.
The JR Act.
The Judiciary Act.
Yes.
Yeah? Does everybody see that? Anybody stuck? Is that helpful? Is everybody following why you've got these different pieces of legislation and how they sometimes work and sometimes don't work? Anthony, that's right, because they're officers of the Commonwealth. Commonwealth employees have to comply with the Commonwealth Constitution, as really we all do, but particularly Commonwealth officers when they're exercising Commonwealth powers. Is anybody stuck, honestly? It's better that we work through these things now than...
Hi Brett, it's Jess here.
Yeah, how you going? You following?
Yeah, good, thanks. Yep, I can hear you. Look, the only thing that I was not sure about is before you said the ADJR Act is a function that gives you the tools you need to get to the AAT.
Well, one of the tools.
Is one of the tools? Okay. So I guess the Section 5 confuses me because it's talking about the Federal Court and the Federal Magistrates Court. And I hadn't heard, I guess, that I hadn't linked the AAT with the ADJR Act until that statement was made. Like I hadn't picked that up in my reading at all. So I guess, should I be going back to maybe probably week 2 and looking at that again, or?
No, I don't want to overcomplicate it. Perhaps ignore what I said there. Really, what I want you to remember when it comes to the AAT, this goes for everybody, the Administrative Appeals Tribunal, is to look to that Act. Let's everybody pull up the Administrative Appeals Tribunal Act. Okay, and pull up section 25. Everybody got that? One sec, everybody. Hello. Sorry everyone, that's the cleaner just popping in to get the bin. Okay, so section 25 of the Administrative Appeals Tribunal Act is the provision that says an enactment may provide that applications can be made to the tribunal, that being the AAT, for review of decisions made in the exercise of powers conferred by that enactment, or for review of decisions made in exercise of powers conferred or that may be conferred by another enactment having effect under that enactment. Now, I don't want you to worry too much about subsection B. For the purposes of this course, it is section 25 1A, which is the critical part. So the confusion, Kylie, might have arisen by my use of acronyms. They become a little bit confusing after a while. Everybody just pick up that piece of paper we're working from. I want you to imagine that you've got section 50, which says the ADJR Act applies, and I want you to imagine that there is section 51, which says that an application can be made to the AAT. Now, section 50 obviously incorporates the ADJR Act into the tools that you have at your disposal to seek judicial review. Section 51 gives you the tools that you need to get into the AAT to seek review of the decision. Right? Is everybody following? I think, Kylie, that's clarified it for you. Might have been a problem at my end. Is everybody else with me? Anyone got any questions arising from that? Okay, so let's just briefly recap. And this is like the problem 23 deluxe version. I've been going an hour and a half on it. So this will just be a very brief recap. Everyone pick up that piece of paper. We've got section 1 establishes the ABRA. We've got section 2, which gives it two purposes. Subsection A is basically that's section 2, subsection A, is a provision which creates the power of the ABRA to act as a tribunal. It's receiving applications and processing them. Now, if we're the victim of some silly decision making when the ABRA is exercising the power that I've given it under Section 2A, what we do is we go down to Section 51 in the first instance, which says you can make an AAT application, and we trot off to the AAT. Now, why do we do that? Because as we canvassed earlier in the semester, it's the cheapest and most cost-effective way to go. And we've got this cascading options of hopefully sensible decision makers, right? Now, if we're the victim of a overzealous decision maker who is doing the sorts of things that I was suggesting to you all before by taking into account something I've heard at the pub, the other option is we say, well, the ADJR Act applies. We can go for judicial review and we can get a declaration that there's been a denial of natural justice in the sense that Brett took into account things which are irrelevant. Took into account things which we hadn't had an opportunity to comment on. I'm getting tired now. Or took into account irrelevant considerations. Then you've got the powers in Section 2, subsection B, and this is kind of like the ASADA type case that we were talking about. We've got a regulatory agency with powers to enforce, and where it exercises those powers that you'll see I provided in Section 4 to issue prohibition notices, if they go beyond that power, we go off to the federal court and we get a declaration if we need to under the standing powers of supervision that are afforded by the Judiciary Act, or because we've got Section 50, we can also ask for judicial review according to the ADJR Act. So that gives hopefully some distinction between where you want to seek judicial review and where you want to seek merits review. Now, have I helped? Is that helpful, or have you got any questions arising from it? It's starting to get repetitive, I suppose. That's a good sign. I've got one. Kylie's with me. Anthony, excellent. Peter, Jimmy. Okay, good. I think we're making progress. Is everybody comfortable with where we're at so far? Or anybody not comfortable, I suppose. It's a bit strange doing this a little bit through Blackboard, I suppose, because it's hard for me to gauge whether or not your faces are telling me a story about whether you're with me or not, which usually I have the benefit of in a courtroom setting. So let me go back to the notes for a minute and back to, yeah, we should Zoom. What we might do for the review session or sessions which we do in week 12 is we might try and Zoom for some of them, or even if the numbers sort of tend to stay around 12, I think we can probably Zoom. I think we can do up to 20, so we'll table that. Gordon, what about the problem question where the agency is holding Lamb to ransom with his equipment? Okay, so that's where we're going for relief, and your homework, starting to sound like my mum who's a school teacher, your homework is to have a look at the ADJR Act and have a look at what it might provide about remedies, and if not, just have a look at some of the authority cited in the Essendon decision for the types of remedies which the federal court has available to it. But generally speaking, what we'd be asking for is a declaration that the ABRA had, well, the first thing we're going to look at, Gordon, in the problem question is, did this agency even have powers to go to his house and take this property. Because if it didn't, we're going up to the federal court and we're going to ask for a declaration that it never had any powers to do that, a declaration that it acted beyond its powers, a declaration that it has to, that it's not allowed to hold that property, and a type of injunction requiring it to return the property. If it did have that power, but because natural justice is not ousted, so therefore implied as a requirement, and because natural justice includes the fair hearing rule, and he was never given an opportunity to be heard before it, that is the ABRA, took this action to seize his property, then we'd be asking for a declaration that it failed to accord natural justice, and we'd be seeking the same, what's called consequential relief. So when I said we'd be asking for an order that the property be returned, what I'm talking about there is basically consequential relief. So there's two types of things that you ask the federal court for. Firstly, the substantive declarations, or the footing which gets you ultimately the practical outcome you want, which in this case is a declaration of a failure to afford natural justice. And then obviously as a consequence we'd be saying, because there has been a failure to comply with the principle of natural justice, when they took the action they did, they acted beyond the law, and we want some orders which will bring them back into compliance with the law. Look, damages are a different issue. You'll learn about that hopefully later in your degrees. The short answer is yes, but I'm not going to canvass why that's the case, because it's beyond the scope of this particular subject, and administrative law is complicated enough, I think, when you're first starting out with making it more complicated. But if loss could be, if there was wrongful interference with his property, which is a type of what we call in torts conversion, and as a result of that conversion, in fact I think conversion gives rises to damages as a matter of course, rather than needing to demonstrate any loss. But assume for a minute that there was some loss of revenue, then you'd have a tortious remedy, but I don't want to go into that anymore. That's really just for your general trivia, or your legal trivia anyway. Joel, would they look into reasons why he hadn't applied for his license, or just review the decision made? So let me just read the question again for a second. I've been going on and on about my own super problem 23 that I've forgotten the facts of this one. Give me a second. Okay, so were they looking to reasons why he hadn't applied for his license? Certainly, that's the whole point of requiring, for example, not the whole point. One of the reasons, one of the public policy reasons for having this requirement of natural justice is demonstrated in part by this particular problem question. So Aaron's been operating his small business for some time, but there's now this act that's been brought in that changes whether or not he can continue to conduct that business. Now, there are all sorts of reasons why a person may not apply for a license. He may have been ill. He may have been out of communication. He may just not have been aware that he needed to apply for a license, which is why you approach him in the first place before you take action against him, to say, look, A, are we correct in understanding that you don't have a license? And B, if that understanding is correct, can you tell us why you haven't applied for one? Now he might come back and say, as to A, I do have a license and you've got a problem with your records. Or he might say, yes, I don't have a license, but B, the reason I don't have a license is I wasn't aware that I had to apply for one. And in our traditions of, and in society such as this, I think it's fair to say that the preference would be that before we have government taking punitive action or otherwise interfering with individual liberties, we give them an opportunity to bring themselves into compliance with the law. Does that answer your question, Jolyn?
Yeah, so the court would, they would do a review of the decision, whether or not it was, whether they had the power to go in and take his belongings, and then they would ask him what the original decision maker probably should have asked him to start with. Is that right?
It really depends on how, in our legal system, the parties frame the questions. And that's why you as future lawyers are important, is because you have to know how to frame the question and what questions to frame. So in this particular scenario, the first thing we'd be doing is looking whether or not this agency had the power in the first place. If it did have the power, we'd be having a look at how it exercised the power, and we would be saying to ourselves in the context of this week's work, well, it had a power, but there was no ouster in the Business Regulations and Control Act of a requirement to afford procedural fairness. So before it went in and took his goods, it should have said, can you explain to us please why you don't have a license? Because he might have turned around and said, and this is what the law wants to happen, or this is what tends to be the public policy behind laws anyway. What most governments whose policies are what are ultimately enacted into law want to happen is for these sorts of things to be brought to the attention of the relevant party, and then for them to bring themselves into compliance. And so part of the reason behind, part of the public policy behind these particular laws are what would be expected of the ABRA is to write to LAM and say, you don't have a license, and LAM might write back, and if LAM writes back and says, oh, I'm sorry, I didn't realise I had to have one, where's the application form, can I please fill one in straight away, then all's well. If LAM writes back and says, yeah, I don't have a license and I don't care for your whole licensing thing, as far as I'm concerned I can do what I want, then LAM might have some serious problems getting the courts to do anything for him. Has that answered your question, or have I misunderstood it?
Yeah, no, that's fine. Yeah.
You sure? It sounds like, no, you haven't really, but I don't want to tell you you haven't answered my question.
No, not at all. No,
Okay.
I think that has answered my question.
All right, good. Gordon, that's an interesting question. Because not everybody has finished their assignment yet, I don't want to go too much into the ASADA decision, but I tell you what, post it on the discussion board, see what everybody thinks, see if we can generate a bit of conversation, and next week when all the assignments are in, we can go through a bit more detail of ASADA if you like. How does that sound? I suspect nobody wants me to give away all the answers to the assignment before all the assignments are in, or is anybody against me on that? All right. Well, the last thing I want to say is don't forget the rule against bias. So the fair hearing rule, and you've got the fair hearing rule, and you've got the rule against bias, both of which are important sub-rules of natural justice. It doesn't really arise on problem question 23, but you never know if A, you're going to need an exam, or B, one day an Aaron Lamb might walk in off the street and say to you, I've got this decision maker who I played footy against last week, and we won, he lost, and now he's refusing to give me a license. So, you know, it's a pretty crude example, but just always have that in the back of your mind. Okay, well, that's a bit over an hour and a half of tutorials. I don't know about you, but I'm pretty exhausted. Any last dibs for questions, or are we ready to pack up and join the rest of the world?
Brett, will we be having this next week, or what's happening over the Christmas period?
Yeah, I just realised today that Wednesday next week is Christmas Eve. So what I'll probably try and do is send out a email later in the week. Everybody perhaps try and keep Monday night free. I think that's when we did it last time, wasn't it? Didn't we reschedule for Monday night? Is Monday or Tuesday night I can't do. I don't suspect too many people are keen to do it on Christmas Eve. So we might try and schedule it for Monday and get it out of the way early. Does that conflict with anybody else's lectures? Or tutorials rather. I forget these are the tutorials rather than the lectures. Is it not good for anybody? Speak now, forever hold your peace. What's the assignment for, Ginny? Okay. We'll work hard over the weekend with your assignment, and what we'll try and do is reschedule it for for Monday night. All right, everybody. Well, we might wrap it up there. Enjoy the rest of your week, and chat to you next week.
Thanks, Brett. Bye.
Okay, guys. Bye-bye.